Good morning, everyone. Today is Tuesday, December 6, 2022. It is 9 a.m. We are here in council chambers for the hearing examiner hearings, which I'm now calling to order. Before we actually start, I have some preliminary comments. I'd like to introduce the process that we follow here in the city of Cape Coral, because it's a little bit different than what's followed in other municipalities and other jurisdictions. The clerk will read the introduction to the case. The clerk will then swear in anyone who is testifying, and city staff will testify regarding compliance with the public notice. If public notice is found, then we go forward with the case. If it is not found, then we take another route. The applicant goes first and presents an entire case, assuming public notice has been found, and then the city staff will go second and present their case. If you're here for public comment, please make sure your comments are comprehensive, because once a public comment is closed, it will not be reopened. The applicant then responds to questions, if any, and makes any final comments. The staff does the same, and then the hearing is closed. If you have a cell phone with you today, please turn it off or silence it. Take any cell phone conversations outside the room if possible. And if you wish to have private conversations, please move away from the speaker's lectern so we do not accidentally record your conversation. If your conversation is recorded, it becomes public record at that time. Please come to the microphone if you have comments so we can properly record your testimony. All testimony must be under oath. Members of the public, if any, are requested to go to the microphone on the podium at the side of the room, my left, your right. It has the same video and audio capability as the microphone in the center of the aisle. Anyone who provides testimony other than the applicant and staff is requested to fill out a public participation card so we can properly spell your name in the hearing examiner order or recommendation, as the case may be. If you wish a copy of that recommendation or order, please provide your email contact information. However, once provided, your email information does become public record. With those preliminary comments, I'm turning it over to the clerk to call the first case. Thank you.
Case VAR 22000034, address 3423 Southwest 28th Avenue. Applicant Eric P. Feichthaler, Esquire. Vincent Chang is requesting a variance of 9.31 feet to the minimum 80-foot lot width at the building setback line as required by the LDC to allow a site with a lot width of 70.69 feet in the single-family residential R1 zoning district. The site is located in an area dominated with single-family homes. A larger parent site was split by a former owner in 2004 without city review and approval. The current owner purchased the site in 2007. Staff recommended findings show the applicant has not met all 7 variance standards found in LDC section 3.4.3 and recommends denial. Any person giving testimony today, if you are able, please stand and raise your right hand. Do you solemnly swear or affirm to tell the whole truth and nothing but the truth?
I do.
Thank you.
Thank you, Madam Clerk. Good morning, Mr. Struve.
Good morning, Madam Hearing Examiner. For the record, Mike Struve, Planning Team Coordinator with the City Planning Division. We did notice this case, and that included placing an ad in the news press 10 days advance of this hearing date, sending letters to all surrounding property owners within 500 feet of the site, and posting a sign on the subject property.
I will find the proper notice was given. Thank you.
Thank you.
Thank you. Mr. Feichthaler, come on up. Thank you.
Good morning, Your Honor. My name is Eric Feichthaler. I'm an attorney for the law firm of Baran, Adamski, Feichthaler, and Sanchez. I'm here to represent Mr. Vincent Chang on this setback variance request today. Before we begin, my apologies. I've not done one of these in a while, and we did have the hearing notice right before Thanksgiving break, which stated that I had to provide materials to you prior to November 29th. I do have a copy of the presentation that I prepared. I'm willing to give it to you, certainly. If it's against protocol, I will not. But if you would like, I'd be happy to give you a copy of what I'm going to present now.
Well, the only thing that I would accept is your comments prior to today that's contained in your letter, because all documents need to be provided prior to today.
Okay.
You can certainly read whatever you want into the record, but we can't accept documents.
And that's fine. And for the most part, any kind of visuals will be provided by city staff as well, I believe, in their presentations, so it should be okay. I'm going to give a copy to Mr. Struve.
And we do have your Exhibit A, so.
Okay, very good. Thank you, ma'am. So, as stated, the applicant is requesting a variance of 9.31 feet to the minimum 80-foot lot width at the front building setback line of subject property. Subject property is a canal front property in southwest Cape Coral that is generally built out for the most part. All the houses to the north are built out, and I'll note later, all those homes are built to the front 25-foot setback line. A brief history of the property in question. The property was part of a larger parcel, which included property to the south until December of 2004. You'll recall that our last real estate boom was around that time, and several people engaged in, I will call them unorthodox lot splits to maximize the number of lots they could sell at the highest possible dollar. The owners at that time, which were unrelated to my client, recorded a deed to split the parcel into two, and that property was split at that time. My client is not a resident locally, he's a resident of California, was not aware of the prior split or that any issues could occur as a result of that split. My applicant purchased the property for $260,000 on October 16th, 2007. Any kind of market analysis will show that was excessive at the time. 15 years later, that price is still probably excessive today. Unfortunately, the applicant was not well versed on the real estate market here and was basically taken advantage of. However, since 2006, when he purchased it, 2007, the owner has dutifully paid property taxes to both Lee County and the city of Cape Coral every year. At the time, like most people believe that are purchasers, the 10,000 square foot minimum was in existence the way they split it, and he believed and continued to believe that he could build a property like anyone else in the neighborhood. Without the variance we're requesting today, this parcel will be forced to have a substandard house constructed compared to others in the area, greatly diminishing the value of not only this property, but the surrounding properties as well. Applicant requests the variance be granted, and that such approval is just based on the following factors. As you know, Your Honor, there are 7 standards for variance that are in the Land Use and Development Regulations. I'm not going to list them all out, but I'd like to go through them one by one and how it applies to this case, and advise or state that our opinion is this application does in fact meet all 7 standards. The parcel clearly does have special conditions in the fact that it is oddly shaped and getting larger from the street level to the canal side. And it has those special conditions due to no action of my client. The special conditions are peculiar to the others and the vast majorities of properties in the area, as well as the R1 zoning classification throughout the city. As a non-resident, my client had a justified expectation to be able to build a single-family home as any other would in this area. The condition that does exist is relatively minor, though, from a width perspective. It has a lot width of over 70 feet at the setback line, but if they're required to build back to where it's 80 feet, it will have a large impact on what can be constructed. I did want to make one note that the main reason we're here today is back in March and April when my client first was contacting the city advised that this parcel was unbuildable at any setback line without the granting of this variance today. The staff report will show that it is buildable at a much further setback line, but my client was told in writing, and I brought that email with me today, that they could not build at all without the variance today, which again, if that were the case, would lead to, in our opinion, to a governmental taking. As I noted before, the special conditions cannot be caused by the applicant themselves, and that certainly has not happened here. An interstate buyer is not aware of every rule that applies in the city of Cape Coral. They did confirm the 10,000 square foot lot size and had no reason to believe they couldn't build as anyone else could. Facially, the special conditions were not caused by my client, and if anything, my client is a victim of the last real estate boom and the things that happened toward it and the misdeeds that were done by others, like the splitting of this lot. No special privilege can result from the grant of this variance, and it will not in this case. It will simply allow to construct a home in the neighborhood just as any other owner would be able to do. As noted by staff in their report, which you may have already read, a property in the same block with nearly identical characteristics came before the hearing examiner in 2011 and were granted a variance with almost identical facts.
I think that was the Board of Adjustment and Appeals.
I apologize. I know it was a different procedure, but then my apologies, Your Honor. But it was decided here that was proper, and in that case, the lot was actually even narrower than the subject lot at the 25-foot line by 2 feet, so a greater variance of over 11 feet was granted in that case, and we do propose that this precedent be followed today to avoid disparate treatment of the applicant. In my materials, I show the photo, an aerial, which is literally 2 lots over from this lot, And you'll see visually it is identical in the way it's shaped and the way it's presented, just southern facing instead of eastern facing like ours. Hardship has to be presented to for a variance to be granted. In this case, certainly a denial of the variance will deprive the applicant of rights that are enjoyed by the surrounding property owners. The city would force this property to have a setback line substantially further from the road than the neighbors, creating a lack of uniformity and an unreasonable restriction in building on the property. It will also potentially result in an inferior construction that, again, will not fit in with the surrounding waterfront properties and could bring down the values both of my client and surrounding properties. So therefore, this request does meet Standard 5 relating to hardship. The public interest must be served if the variance is granted, and we do submit that it would be in this case. The future development is in harmony with the intent of the Land Development Code, which is for full development of properties to setback lines, as nearly every property is in this area. If the city requires an artificial setback with the ability to build only a small home not fitting with the waterfront properties in the area, it would then not follow the development pattern that has occurred in this area. Every house to the north on this same street lined up with this property are built to the setback line, and this again would create an unusual situation in the neighborhood. I don't believe neighbors have objected to the variance as of the submittal by the city. They had not. I don't believe there had been any objections to granting the variance. And again, the public interest would not be served if in 2011 an identical variance was granted, and in this case it would not be. That would not serve the public interest. So in conclusion, we submit that the applicant in this case has met all 7 requirements necessary for the variance to be granted. The fact that the precedent does exist from 2011, we hope that the court will find that that your hearing examiner will find that very instructive, and that the similarly situated applicants would be treated the same as they were previously. And again, if denied, the applicant would have no choice to build a home that is substandard and a neighborhood of waterfront homes, and potentially, according to some city staff, may not be able to be constructed at all. Therefore, we do ask that you consider approving this variance this morning, and we stand ready for any questions from you or from city staff.
Thank you. What do you consider substandard? You've said several times substandard, inferior, small home.
So the average home in this area, and I don't have exact numbers, but the minimum site amount being under 1,500 square feet, there's no houses being built like that. I did some math, and I believe that the end result is probably 2,500 square foot total footprint smaller than they would have be able to have otherwise. It would be substantial. So you would be farther back from the road. You'd have a much smaller footprint on the home. It simply wouldn't be fitting in. So certainly they can use fine materials to use, but it would not fit in with the rest of the community, both on and off water lots.
But I don't. I appreciate what you're saying, but what do you consider substandard?
I would say substandard is someone that's required to build a much smaller home on a lot that is required to be a much more expensive property. So waterfront properties, as you know, people generally wouldn't buy them to build a starter home on the property. Without this variance, what's going to be required is essentially either a starter home or a very small footprint 2-story home, neither of which would be fitting in the community.
Okay, thank you.
You're welcome.
Okay.
Good morning again, Madam Hearing Examiner. For the record, Mike Struve, Planning Team Coordinator with the City Planning Division. And for the purposes of this hearing this morning, I'm requesting to be recognized as an expert in the area of land use planning based on my credentials on file at the City Clerk's Office and my past testimony before you previously on similar matters.
I will find you as an expert based upon your past testimony regarding issues that are similar to those that are presented today and based upon your CV on record with the City Clerk, excuse me.
Thank you.
Thank you.
So this is a privately initiated variance request by the owner, Vincent Chang. You already heard from Mr. Chang's authorized representative, Mr. Feichthaler. And the owner is requesting a variance of 9.31 feet to the minimum 80-foot lot width requirement at the building setback line to allow a site with a width of 70.69 feet. And this would allow, that variance would allow the homeowner to construct a single-family home on the lot at the 25-foot setback line, which is the minimum front setback allowed in the R1 zoning district. The site is located at 3423 Southwest 28th Avenue. The site's in southwest Cape Coral, south of Gleason, and east of Surfside Boulevard. And here's an aerial of the site. Site is located in an area that contains exclusively single-family homes, although you do see a couple of scattered vacant single-family home sites, even a couple close by to the subject site to the south. The subject property and all subject properties within 500 feet of this site have a single-family future land use classification and single-family residential or R1 zoning. Mr. Feichtvaller did a good job of going over the background. I'll just very briefly summarize some of the more salient facts here. The site is 10,000 square feet, so it has an area to support a single-family home. The lot was split in 2004, not by the current owner, but by a previous owner. And at that time, a portion of Lot 3 was added to, or I'm sorry, a portion of Lot 4 was added to Lot 3. This variance is requested to allow for the construction of a single-family home where the parcel would have a width of 70.69 feet again, and that would be at a setback of 25 feet from the front property line. This is a survey of the site provided by the owner's representative. You'll notice here that, if I can highlight this, this is the 25-foot setback line right here, which corresponds to a lot width of 70.69 feet. And then in order to comply with the minimum width requirement at the building line, the setback would need to be located further eastward, considerably further eastward, to roughly around 45 feet, and that's an approximation. But that would be where the lot first enjoyed a width of 80 feet. Staff has analyzed this request with those 7 standards that appear in the Land Development Code, and I do want to point out that our staff's findings are recommended findings, as the hearing examiner is the final judge of findings in situations or in cases like this. The first standard involves, are there special conditions or circumstances that exist that are peculiar to the land structure or building involved and which are not applicable to other land structures or buildings in the same zoning district. So the site is somewhat irregular from a previous lot split. That doesn't necessarily set it apart from other sites, though, in the city, because there are some other sites that have an irregular shape, particularly those along canals, and particularly those along cul-de-sacs along canals. The site does have adequate area and depth, but it does lack the required width at the minimum 25-foot setback line. And because adequate width exists elsewhere on the site to allow for the construction of a single-family home, staff finds that this standard has not been met. Second standard is, are there special conditions and circumstances that do not result from the actions of the applicant? So I mentioned earlier, this lot and several other lots were split back in 2004, not by the current owner at the time, but by a past owner, and those splits occurred without city approval, and the city really did not have a good process at that time for reviewing the either splits or combines and doing that in a cooperative fashion with Lee County like we do now. So unfortunately, there have been a number of lots over the times that in some cases lack that minimum 80-foot width at the building line requirement. In some cases they lack minimum 10,000 square feet. In some cases with lots that have marine improvements on them, that has resulted in setback infringements, with that marine improvement now being too close to the new property line. Based on the letter of intent, the current owner was apparently unaware of potential problems that were created by the lot split. However, staff does find that special conditions are absent in this case because there is sufficient lot area and depth and width that occurs elsewhere on the site, again, to allow for the construction of a single-family home on this property. The third standard is, will the granting of the variance confer on the applicant any special privilege that is denied by these regulations to other lands, buildings, or structures in the same zoning district? In this case, the narrowness of the site will result in a setback that is considerably larger than the minimum 25-foot setback that can be observed for most single-family residential sites in the city. And based on our review of this case, that setback would be somewhere around 45 feet. That would be the minimum setback necessary to comply with the 80-foot width at the building line requirement. That being said, despite the larger than normal setback, an adequate building envelope does exist to support a single-family home on the site. And since the owner can construct a single-family home on the site in compliance with the Land Development Code without the need of a variance, staff believes that the granting of the variance would confer a special privilege to the owner. So we find the standard has not been met. Fourth standard is that the literal interpretation of the provisions of the regulations would deprive the applicant of rights commonly enjoyed by other properties in the same zoning district under the terms of these regulations and would cause or impart unnecessary and undue hardship on the applicant. Again, in this case, unable to construct a single-family home on the site, a greater setback would be needed to comply with the minimum width requirement. And what the applicant here is losing on this site in terms of complying with that minimum lot width requirement is flexibility and a design that the applicant would otherwise prefer on the site if they were able to develop at the 25-foot minimum setback. That being said, there is still adequate room to allow for a single-family home on the site. And since a single-family home can be constructed on the site, a denial of the variance would not deprive the owner of rights enjoyed by other owners on similar zoned property. So we find that the standard also has not been met. 5 is that the variance granted is the minimum variance that will make possible the reasonable use of the land, building, or structure. I think this was something that Mr. Feichthaler had alluded to. The city does have a minimum area requirement for single-family homes, and that area requirement varies depending on whether you're on a golf course or on a canal or if you have a dry lot. In this case, the city requires a minimum living area of 1,400 square feet for single-family homes that abut or are located on saltwater canals. And again, despite the larger setback that would be required in this case, in the absence of a variance being granted, staff does estimate that a substantial building envelope would exist on this site. And this estimate lacks precision, but we estimate that a building envelope somewhere in the neighborhood of 3,000 square feet would exist on the site. And since an adequate envelope does exist, the variance requested is not the minimum variance needed in this particular case. And so staff finds that this condition, or this standard, I should say, has also not been met. 6, the granting of the variance will not change the use of one that is not permitted in the zoning district or different from other land in the same district. In this case, the variance will have no bearing on the use that is being sought by the applicant. Single-family homes are allowed in the R1 zoning district, so this standard is met by the applicant. And then lastly, number 7, that the granting of the variance will be in harmony with the general intent and purpose of these regulations, and that the variance will not be injurious to the area involved or otherwise detrimental to the public welfare. In this case, the granting of the variance, we find, would not be in harmony with the general intent and purpose of the Land Development Code, as all variance criteria are required to be met for the awarding of a variance. And based on our recommended findings, the owner has failed to meet several variance standards associated with this request. Secondly, in terms of whether the variance would be injurious to the area or incompatible with the area, the awarding of the variance would allow for the construction on a narrower part of a lot with respect to other sites in the area, outside of the previous variance that was granted to the east of the site, and staff believes that that would be at odds with the established development pattern in the area where the other sites are developed in conformity with that minimum 80-foot lot width requirement. So we find that the standard also has not been met. In terms of comp plan policy, there's not a whole lot here to review, except that the future land use of the site, which is single family, is consistent with the R1 zoning of the site, and following a construction of a single family residence on the site would have a density of 4.4 dwelling units per acre, which is the maximum allowed by that future land use classification. So there is that particular policy is consistent with what the applicant is trying to achieve on the site. Because not all standards have been met in this variance application, staff is recommending denial. We have received no written correspondence on this case, and we've received no phone calls on this case, and I'll stand by in case you have questions for me.
Thank you. Did you want to incorporate your staff report?
Yes, please.
All right, thank you. I'll do so. I have no other questions. This is a public hearing. Are there members of the public who wish to provide input or testimony? Seeing none, I'll bring it back to the applicant's representative. Sir, any further comments or testimony?
There is one other item I'd like to state, if it's appropriate. And again, I realize with the timing, and I apologize. I discovered this email after the deadline that is a public record, was sent from Director Cotero, that I would like to read verbatim part of it to you into the record, if it's appropriate.
I'm sorry, it was an email received by the city or?
An email written from Director Vincent Cotero to me on May 9th, 2022 regarding this case.
Sure, if you want to, go ahead.
I'd appreciate it. And it relates to what I said earlier about the city's position initially was, without this variance, contrary to Mr. Struve's comments, that this lot is not buildable at all. So in relation to that, his email to me of May 9th, 2022, sent at 8:30 a.m. This, by the way, was copied to Robert Peterson, who had written emails earlier confirming this same information. He lists 3 lots because there were 3 lots that he was looking at in question, one of which is 3423 Southwest 28th Avenue. And I'm reading this verbatim. Each of the lots listed above do not meet the minimum lot width requirement of 80 feet as measured at the 25-foot front setback line. At the time these lots were created, Land Use and Development Regulations Section 4.2.I.3-4 required all subdivisions of land to comply with all zoning regulations and stated that, quote, no building permit or certificate of use shall be issued for any structure or use on a lot or parcel created in violation of this ordinance. Accordingly, in 2011, the city placed a restriction on these lots, noting that a variance is required for the non-conforming lot width. I believe the necessary procedural step to allow construction on the vacant lots would be a variance. And then the final sentence, or second to final sentence, if your client wishes to proceed with the variance application, I see no reason why my staff would not look favorably upon the petition. So I only bring that up because, again, there is also a differing of opinion with the city whether this property can be developed at all based on the fact that this lot was split the way that it was. But I do note that in that, what I just read to you is 2011 where the restriction was placed, which was 4 years after my client acquired these lots.
Thank you.
Thank you for allowing me to read that in.
All right, thank you. Mr. Struvic, oh, yes, Mr. Leclerio?
The only thing I'd add on that, John Leclerio, City Attorney's Office, the only thing I'd add on that point is, it sounds like, and we weren't party to that, staff wasn't party to that letter, so first time I'm hearing it, but it sounds like the director was inviting the applicant or through his agent to apply for a variance. At that time, staff had not seen any documents, haven't analyzed the variance request, and now they have.
Right, I appreciate that. All right, Mr. Struve, can I have you up, please? Don't want to put you in the awkward position of being at variance with the gentleman who is in charge of the department. But can you explain to me what your thought is that Mr. Cotero had said something and the staff report says something else? I guess what I'm saying is, would you concur with Mr. Leclerio, or do you have another thought?
I would concur with Mr. Leclerio on that the applicant in this case, and I think there are also a couple of lots to the south that lack that minimum 80-foot lot width requirement at the 25-foot setback line. They're welcome. They're invited to apply for a variance if they don't want to comply with the standard that's set out in the Land Development Code. And just to add to that I do not see that this lot in any way is unbuildable, with or without a variance. Without a variance, the applicant can come in and construct the house at the point in the lot in which he has a minimum lot width of 80 feet, which is somewhere in the neighborhood of 45 feet. And if the variance is granted by the hearing examiner, then he can construct a single-family home at the more traditional 25-foot setback. But to say that this lot would be unbuildable, I would agree with the applicant there. That would be, I think, akin to a regulatory taking, and I don't think the city is has an appetite, for example, to buy this property by denying a single-family home permit on the site.
Thank you. I appreciate your comments. Mr. Feichthaler, any response, or are you good to go?
No, Your Honor, in conclusion, just once again, from everything that I said earlier and the fact that for 15 years this gentleman has waited this long to finally go ahead and construct something, and to be told all this obviously was very shocking and upsetting to him, and just would bring up again that 2011 hearing with nearly identical facts, that the variance was granted rightfully in that case, in my opinion. I hope you'll feel the same way on this one.
Thank you. And
Thank you.
the email from Mr. Cotero was May 9th of 2020.
My apologies, May 9th, 2022, sent at 8:30 a.m. Copied to Robert Peterson and Elizabeth Helsel.
Okay, fine. Thank you very much. All right. If there's no further evidence to be presented in this hearing, I'm going to close the hearing at this time. I'm going to consider everything that was said by everyone and render a order in due course. Thank you, everyone, for coming today. The only other item of business before us today is to announce the date and time of the next hearing, which is Tuesday, December 20th, 2022 at 9 a.m. here in Council Chambers, and we stand adjourned at 9:33. Thank you, everyone.